Hi, everybody. Thank you for joining me to take a few minutes to talk about the relationship between probate and real estate. I'm Candice Carr. I'm an attorney with Ouellette Carr and Spectrum Title Services. I've been practicing for about 9 years now, and I decided to make this quick video because I get a lot of phone calls from agents with questions about properties they are possibly going to list or properties that their buyers are looking at, and they're not sure if they are subject to probate, who potentially owns the property, and what the probate process entails. So we're going to briefly talk about the two different types of probate administrations and some things that you as agents can look out for. So what is probate exactly? The legal definition is the court process by which a will is proved valid or invalid, or the legal process wherein the estate of a decedent is administered. Because you can have a will or not have a will and still go through a probate proceeding. So if there is a will, then it's whether it's proved valid or invalid, and if there's not a will, then it's just the administration of an estate. So when we're talking about real estate, when is property going to be subject to probate proceedings? And that's going to happen if the title to the real property does not automatically transfer upon the title owner's death. So some instances where title does automatically transfer is if the property is held as husband and wife. So if one of the husband or the wife passes, the title will automatically transfer to the surviving spouse. Another scenario is when property is held as joint tenants with rights of survivorship. That's exactly what rights of survivorship means, is when one tenant passes, the title automatically transfers to the surviving joint tenant. Or if the property was set up in a life estate. That's where somebody will retain a life estate or the right and interest in the property for the remainder of their life, and then upon their death it will automatically pass to what's called a remainderment that they've listed in the deed. It could be children, it could be a friend, it could be anybody. So in a life estate, title will automatically transfer upon that person's death. There are a few documents that have to be recorded in order to clear title even when there is an automatic transfer, but those are things that a title company would be able to take care of. Even if the will lists the beneficiary of the property, it may still be subject to probate. So I get a lot of calls from people and they say, well, the will says that I get the property. Okay, but that doesn't mean that the title is clear and that the title to the property has actually transferred to you. So even if there's a will and Jane Doe says, upon my death, I want the property to go to my nephew, it may still be subject to a probate proceeding. Now, as I mentioned, there are two types of probate administrations. There's a summary administration, and then there's a full administration. Now, here we're going to talk about a summary administration. That's essentially a shortened court proceeding. You can often have a court order summary administration in a few weeks. And this type of administration, as with the full, can be done with or without a will. But in order to qualify for a summary administration, there's one of two requirements that has to be met. Either the decedent has to have been deceased for more than 2 years, or the total value of the assets subject to probate is less than $75,000. So if you have a property that's the value is $100,000 and the decedent has been deceased for 6 months, it's most likely going to be subject to a full administration as opposed to a summary administration. Now, in a summary administration, the court order that's entered, that's called an order of summary administration, that order actually acts as the title transfer document to the heirs or the beneficiaries. So once that order is entered by the court, that's something that will get recorded in the public records, and that acts sort of like a deed that actually transfers the title. That order will state the legal description of the property and who it's going to and what percentages. If there's 4 children and each child gets 25% interest, all of that will be spelled out in that order, and that will get recorded in the public records. So that's a summary administration. A full administration, again, can be done with or without a will, but this could take 4 months and usually longer. And the reason being is that in a full administration, there's a 90-day creditor period. And that's a period of time where a notice goes out that there's a probate proceeding, and if there's any creditors, credit card companies, car loans, anything that the decedent owed, they can file claims with the estate during that creditor period. Now, in a full administration, there's a personal representative appointed by the court. That's usually somebody that's listed in the will. Or if there's not a will, it can be any interested party that's approved by the court. They can sell the real property if the will gives them the power to do that, or with a court order. Most of the wills that I've seen and that I've prepared do allow that authority to sell the real estate. They give that authority to the personal representative. But if it doesn't, then the court can enter an order authorizing the sale. And in order to do that, they would want to see an executed contract, and they would want to see comps or a letter from an agent stating that is the fair market value of the property, and they'll review all of those, and they'll enter an order authorizing the personal representative to sell the property. However, the proceeds may or may not be dispersed upon a closing, depending on whether or not that creditor period has run. A lot of judges these days will require any funds from the sale of a real property to be placed in what's called a restricted depository until that creditor period has run. They don't want any of the heirs or the personal representative spending any estate funds until any claims have been either cleared or paid, or sometimes they may be deemed invalid. So the personal representative can sell the property, they can sign the closing documents, but the proceeds may not necessarily be dispersed to the estate. The closing fees and commissions, etc., things like that will be paid, but any proceeds to the seller or the estate may be retained in a restricted account. Now, what do you need to know as an agent, either looking to list a property or looking for your buyers to potentially purchase a property that may or may not be involved in a probate? The first thing, if you're on the listing side, is who is your seller? Is your seller the estate? Does the personal representative have the authority to sign a listing agreement, to sign a contract? Or is your seller a beneficiary? Maybe the property has already gone through probate. Most of the time, I think you'll find when you go to list a property, it's either in the middle of the probate or the probate has not yet been filed. And that's something you'll want to discuss with your sellers, is getting that probate started early on, because especially if you're going through a full administration, it's only going to cause more delays if it has not yet been started. Now, once you know who your seller is the property even subject to probate? Did title automatically transfer upon the death of the title owner? Or is there a will, or there's not a will, and the property needs to go through probate to determine who the beneficiaries are? Now, has the probate been filed? So like I just explained, is you want to get that process started early on if it has not already been started. And if it has been filed, then you probably want to get on the phone with the probate attorney to find out where it is in the process, projected time frames. Are there any siblings that are fighting over the property? These are all things that can cause delays in closings. Have any objections or claims been filed? Again, these are things that can cause delays. If somebody's objecting to a will, a sister who doesn't like their brother that's appointed personal representative, and they've maybe objected to the will under fraud, or there's a whole host of reasons somebody could object to it. These can cause delays in closings, or possibly there could be no closing at all. And what are the time frames you're looking at? Is this going to be a summary administration where there could potentially be a final order in a few weeks? Or is this going to be a full administration that can take at least 4 months, usually longer? Do you want to know what kind of time frames you're dealing with in terms of being able to sell it and close? And these are all things, again, that a probate attorney can answer for you. So again, thank you for joining me. I hope you got a lot of useful information. Here's all of my contact, my phone number, my email, our title company website. Please give me a call if you have any questions about real estate or probate, and you're not sure of either one or a property that you're dealing with. I'm happy to help, and I look forward to working with you on your next probate and your next closing. Take care.